Assalamu alaikum wa rahmatullahi wa barakatuh. Good afternoon, ladies and gentlemen. As mentioned by Eric, my presentation basically will be limited to the recent trends by the international arbitration institutions in terms of the case management. A study actually conducted, let me just turn the, so I'm waiting for the slide actually, but let me carry on actually. A study conducted by the Corporate Council International Arbitration Group showed that 100% of the Corporate Council that have participated in the survey believe that arbitration takes too long and costs too much. Another actually survey conducted by the Another survey conducted in 2015 by Queen Mary University and White & Case. The respondent on that survey, around 66% of the they believe that arbitration is costly, and around 36% of the people who participated, they believe that there is a lack of speed in arbitration. There has been a recent notable trend, both at the legislative level as well as the institution level, adopted time and cost-effective measure. Most and major arbitration institutions have extended effort in recent years in order to introduce rules to regulate the cost and time, placing a duty on the parties, including the tribunal, to conduct arbitration in timely and cost-effective manner, providing arbitral tribunal, and depending on the circumstances, with the necessary powers to issue case management decisions to conduct the arbitration in the manner it considers appropriate. And the obvious example is Article 14 of the LCIA rules of 2014, as well as Article 17 of the UNISTRAL rules of 2010. Some examples of the case management techniques used by the arbitral tribunal are, for example, dividing the key issue and rendering one or more partial awards. And by this technique, basically, it will lead the parties sometimes to settle the dispute when they will realize that the partial award is against them, or there is a trend that it will be against them in the future. In a large and complex cases, it is useful and efficient to divide the proceedings. For instance, to decide on the issue of liability prior to entertaining the amount of the damage. However, from the enforcement point of view, the issue of liability, from the enforcement point of view, this could create a problem. And here actually I mentioned a decision issued by Dubai Court of Cassation. And the purpose to highlight this decision is not to criticize the courts. As a practitioner, actually, I learned a lot, and I do believe that the courts in UAE, and in particular Dubai, actually, they are friendly to a large extent with the arbitration. But here to show basically that even though if you have a modern arbitration law and a modern arbitration rules by the institution, if you will not get the support by the judiciary, there is no any benefit you can get, because end of the day, the beneficiary basically they will monitor. So in the decision, or the two decisions I highlighted here in my presentation, there was a partial award issued by a sole arbitrator, and the arbitration was seated in London under the rules of the LAMM, the London Maritime Arbitration Association. It was about the lease agreement of a vessel. So the sole arbitrator decided to issue a partial arbitration award about the lease, the lease period amount, And later on, basically, he will decide on another award about the compensation. When the claimant took the partial award to the Dubai Court of Cassation, to recognize and get the enforcement, the respondent approached the court as well to ask the court to refuse recognition and enforcement of the partial award based on a point related to the domestic law. The point was basically, he raised the point that the person who signed the arbitration agreement doesn't have the capacity to represent the respondent. The court of first instance, basically, they ignored this challenge and they decided to recognize the award. The same thing he appealed the decision, and the court of appeal, they accept to recognize the award. Then he approached the court of cassation, which is the highest court. He raised the challenge of the lack of capacity under the UAE companies law. The court of cassation basically highlighted a very good point, that the challenge of raised by the respondent to refuse recognition of the award based on the lack of capacity should consider the law of the seat under the New York Convention and not the local law. And this is very good award. But the strange thing, after a while, when the claimant had the second award on the compensation, he approached the court again to get the recognition. And the respondent approached the court with the same challenge about the capacity. Unfortunately, the Court of Cassation, with some other judges, they decided to refuse the recognition based on the lack of capacity of the person who signed the arbitration award based on the domestic award, which is contradict with the other award. So we had two contradiction award. The partial award was recognized, and the final award, it's been refused to be recognized. So this is one of the issues, actually. It's good to have the case management. It's good to have a modern legislative, but at the same time, you need the court to support these provisions. The other technique is emphasize on the use of technology. For example, hearing may be conducted through modern means of communication, where attendance in person is not essential. And we have basically Article 21.3 of ISCA rules. We have Article 33.3 of the UAE, the recent UAE arbitration law, confirming the same meaning. Relying on documents only, Article 24.7 of the ISCA confirming this meaning as well. In cases where the issue to be decided is based on the documents rather than through oral evidence. ICC also expedited procedure rules have the same meaning. And we had the incident basically recently with the ICC. Okay, it's fine. Actually, we had a recent case with the ICC under the new rule of the expedited procedure rule. The claim amount was very less, and at the first conference call between the ICC Secretariat and the parties, they managed to convince the parties to amend their agreement. Instead of having 3 arbitrators, to have a sole arbitrator. Then basically the council themselves, they decided to educate their clients to have the expedited rules rather than the normal rules of the ICC. And it shows, actually, this case give a good example of how basically the ICC Secretariat are very proactive in terms of educating the parties about the techniques which will reduce the cost and time. I have actually lots of things about the case management pre-hearing conference. For example, the documents, relying on the documents rather than the hearing. The expert opinion, for example, sometimes it leads to a long process and cost, while we have some rules through the different arbitration institutions. encourage the parties basically to reduce unnecessary and repetition and the documents and the expert opinion, to have basically a joint expert opinion rather than different expert reports, limiting the length and the scope of written submission to avoid repetition. Several arbitral institutions provided guidelines for the production of documents, of documentary evidence to reduce time and cost. Due to the time also, I would recommend you to go through the slides. I highlighted some of the articles under the different arbitration institutions. For example, Article 22.1 and 2 of the ICC, Article 10, 20, and 21 of ISCA arbitration rules. It's very useful to go through it, and it supports the case management in order to reduce the cost and the time. In the UNISTRAL rules of 2010, we will find Article 17.1, and finally, Article 14.1 of the DIFC LCIA. This is overview about the case management and the trend used by the international arbitration centers to control the cost and time. And I'll be more than happy to answer any question after the panel. Thank you so much.